¿Qué tal, comunidad? Aquí habla su abogado Ray Ibarra Maldonado. Very special Facebook Live tonight. Let's go ahead and get started. All right, ladies and gentlemen, we're going to start off in English tonight. Vamos a empezar en inglés. Después vamos a ir español. So we had a great Supreme Court decision last week. Everybody was excited. Everybody was pumped up. And unfortunately, just as much as I got to come on here and tell you about the good Supreme Court cases, I got to come in here and tell you about the bad Supreme Court cases. And we had one of those today. We're going to talk about two cases, one Supreme Court decision from today, and ironically, a couple days ago, a Court of Appeals decision that has to deal with the exact same issue. And you'll understand why we have to talk about that, because they're absolutely 110% related. If you can do me a favor, if you think anybody's interested, give us a start with a share, like, comment, let me know where you're watching from. Always love to hear those comments come in. And if you have any questions in the meantime, of course, drop those comments down below as well. So today, we have a decision from the U.S. Supreme Court. Let's get it up here, as we always do, go straight to the court. And what the decision here is, this tells us who voted which way, right? So we have Alito, who wrote the opinion of the court. If Alito wrote the opinion of the court, we just ain't going to like it, more often than not. And he had some very inflammatory one statement that really upset me reading this, and you can tell it was an Alito written opinion, along with Justice Roberts, who was our swing vote last week, Thomas, Gorsuch, and Kavanaugh. And you usually see those guys together, right? 1, 2, 3, 4, and 5. So what we've seen lately in Supreme Court cases is 5-4, 5-4. With the 5 lately being us winning, here you have the normal 5 you would see together, but you have over here Thomas, with Jones concurring, and you have Breyer, and filed an opinion concurring in the judgment with Ginsburg. So I saw a lot of people today attacking Justice Ruth Bader Ginsburg, saying she turned her back on the immigrant community. I mean, it's harsh stuff. So we want to definitely get up here and talk about that. And then we have our, seems to be our voice of reason on the U.S. Supreme Court, Justice Sotomayor with Judge Kagan joining in the dissenting opinion. Dissenting means didn't agree with the decision, thought it should have came out the other way, and I'll explain why that was. All right, and I'll go into the Ginsburg discussion, why you're seeing her with those justices, why it looks really bad, and what it really means and how I interpret it. All right. So what is this case? What on earth are we talking about? All right, so let's get it started here. Someone who comes into the country like this gentleman did, he came in through a place other than a port of entry in the desert. When he was stopped by Border Patrol some 25 yards into the country, he said he was afraid to go back to his country of origin. Those are the magic words that should trigger then an interview with an asylum officer, where he has the opportunity to prove his case to that asylum officer. If the asylum officer doesn't agree, there's a significant possibility that he'll be harmed upon his return. He can say, I don't believe it, I'm going to put you back in what's called Expedited Order of Removal. Now, that decision can be reviewed by the supervisor, which it generally always is. And then the supervisor reviews it. If the supervisor agrees with the asylum officer, the person can ask the immigration judge to review that decision. For the longest time, that was what we had here. That's the program that we were working under. So someone comes in, the immigration says, hey, you've been here less than 14 days. Less than 100 miles from the border, we're going to put you in what's called Expedited Order of Removal, which means we're going to kick you out of the country quickly and give you a formal deportation that will forever be used against you for the rest of your life, and you have no right to see a judge. The statute provides, though, if you use those magic words, I'm afraid to go back, you're supposed to be given this process of asylum officer, supervisor, then the judge. Well, that's how it's been for the longest time until the Ninth Circuit Court of Appeals disagreed with that. So the gentleman here, and I'm sorry I keep saying the gentleman, but it's really difficult for me to mispronounce his name. Easy for me to mispronounce his name, so I don't want to even attempt it. I think that would be embarrassing and disgraceful, so I'm not even going to try. I'll say the gentleman. The gentleman wanted to stay in this country fearing violence in Sri Lanka. What he told the Border Patrol agent, allegedly in the record, is very limited. What he told the asylum officer as well, he probably didn't have an attorney at the time, probably didn't have a good interpreter, which they also argued in this case. But nonetheless, by the time he had an attorney, those attorneys made much better arguments, explaining and putting into context that he was beaten for his political opinion and for his ethnicity. So that's where the argument why he should have won asylum. The ACLU and other groups filed what's called a habeas petition with the district court. District court said no, habeas petition is not appropriate. So then we go to the Ninth Circuit Court of Appeals, and the Ninth Circuit Court of Appeals comes out with an amazing decision, a game-changing decision that said we do in fact have habeas jurisdiction to listen to this, and the due process requires that a federal circuit judge be able to review this decision from the immigration judge. So it opened up a whole nother avenue for us to apply to, at least here in the Ninth Circuit. If an immigration judge didn't agree with us, we could ask for a habeas in federal district court. That decision today from the U.S. Supreme Court takes that away. They said, very bluntly, that's not what habeas means. Habeas means someone is unlawfully detained and they're challenging their detention. And what we did here, as in the Ninth Circuit we did, was give habeas review to someone who wasn't challenging their detention. He was challenging the immigration result, the lack of an opportunity to apply for asylum. So Alito was very stern on that. Now, where does it come in here with the RBG, right? RBG agreed with the opinion, but very specifically said, in this particular case. In this particular case, I don't think habeas applies. In this particular case, I don't think due process was infringed. They were trying to leave the door open, so the possibility of coming back to the Supreme Court with a better case, the better facts, a person that's been in the country longer, and here's why this is important. We have to go over to the the Second Circuit case. Get it up over here. This is the one that came out earlier this week, June 23rd. So, backtracking again, the Trump administration put out a call that they were going to use expedited removal instead of just the 14 days to what the statute actually says, 2 years in the country. So anybody that's been here less than 2 years, instead of having the right to see a judge, if you've been here a year and 364 days, you can be put in expedited order of removal, not have a right to see a judge unless you express this fear, and then you're limited to that form of relief. So, the ACLU, other groups sued them as well. They originally won a preliminary injunction in district court that said, we agree with you. You are allowed to enjoin. The district court said, we're not going to let the Trump administration enforce this while we're fighting the case. Trump administration appealed that to the District of Columbia Circuit Court. They came out with a decision a few days ago saying, no, district court judge, you are wrong. They should not be given the preliminary injunction, and the Trump administration can put it into play. Anybody that's been here less than 2 years can be given an expedited order of removal. However, this case was a remand. It was sent back to the district court to continue the rest of the case. What are the arguments that remain in that case? Violation of the APA, violation of due process. So Judge Ginsburg's, and we got opinion here from Mr. Hartman saying I think it's supposed to be not betray us, right? All right, so did not betray us. in the reading that you can put into that here is Justice Ginsburg and Breyer, yes, they did decide against this Sri Lankan gentleman very specifically on the facts of his case as they understood them, but they wanted to leave open the possibility, for example, this DC Circuit case, someday coming back to them, which maybe then, if you have someone that's been here longer than a few moments, they might be able to say habeas could apply. They might be able to say that due process should apply. So we'll be looking anxiously at this court in DC to see how that's decided. But for now, yes, it's a negative decision and a negative decision. Two bad ones today. We lose the opportunity to go to the federal judge and say the asylum officer, the supervisor, and the immigration judge got it wrong. And honestly, ladies and gentlemen, it is pure show. Right? I see, reading this case, I can totally see what went wrong. The asylum officer who did the interview probably didn't have good interpretation, didn't ask the right questions, didn't give this gentleman a chance to tell his whole story, did it quickly figuring it was just going to be upheld by the judge. It was quickly upheld by the judge. They thought that'd be the end of the story. Well, when he has counsel, the story gets told much better because attorneys understand the legal system, are able to spend time with their client and get from them the information they need and prove the case. You saw different facts come out. Now, interesting, probably the most exciting thing about this case was the very end of it. It says that they give the opportunity for this gentleman to again be re-interviewed or have the judge reopen the case and listen to it again. So hopefully that comes out. I'll do my best, Lisa. I'll do my best. Let me get it back up here. Let's get it here. So we have it up here. It's United States Department of Homeland Security. All right. Department of Homeland Security versus Thurgai GCM. Right? There it is. I can spell it. I cannot pronounce it very well. That is the case from the U.S. Supreme Court. If you're looking for the case from that's going back to D.C., that would be Make the Road New York versus Wolf, right? Make the Road New York versus Wolf. That's the case definitely to keep an eye on to see how that's going to come out. And this is the bad case from today. An unfortunate decision, but honestly, as an immigration practitioner, it's not taking me back to a different world than what I knew before. It's exactly the world that we lived in prior to this great Ninth Circuit case that just came down very recently. So we're used to this process and we know how to defend people in that. The key here is being able to get to the person before the interview, explain what the interview is, listen to their story, help them out, help them understand the process and what they're going to be asked. If everybody was entitled to counsel, right, before these interviews, then you would see an enormous even increase in the amount of people that pass it and get put into proceedings because there's a culture shock, there's a language difference, there's all these kinds of issues that go wrong when you don't have an attorney who understands the system advocating for you. Unfortunately, we're going to continue to see that. It was very exciting for the short period of time we had the possibility of going to district court. That's now gone, but we'll see how this DC case works out for the people that have to be here for the 2 years, right? And thank you, Mr. Lopez Anchondo, for putting the case down there as well. Any questions you have, please put them down. I'm going to switch over to Espanol, but if you have any questions, please also put them down, and we'll do my best to respond. Says, Abogado, mi esposa tenía que ir a sacarse el fingerprints UCS, pero a paso del COVID-19 ahora está esperando otra cita para ver si realmente se puede afectar su caso. No, absolutamente no. En USCIS lo cerró por muchas personas por sus huellas. Eso no va a afectar por nada el caso de ella. También hoy recibimos noticias que los cortes aquí en Phoenix lo cerraron de un día a otro, pero ellos saben lo que está pasando. Nada más le van a dar otra fecha, le van a mandar por correo. No se preocupe de eso. ¿Okay? So, comunidad, yo tengo que decirle que hay unas decisiones muy mal que salieron del Corte Suprema y otro Corte de Apelación esta semana. Como venimos la semana pasada para explicar el caso increíble que ganamos en Corte Suprema sobre DACA, también tenemos que venir cuando hay algo muy mal y tenemos que informar a la comunidad sobre eso. El primero que voy a enfocar es un caso del Corte de Apelación, no es el Corte Suprema, primero enfoque con otro, el Corte de Apelación. Este corte nos dijo que era desfortunadamente posible que Trump ya puede poner personas en deportaciones rápidos si tienen menos de 2 años aquí en el país. Que eso es de mucho miedo que está pasando por la comunidad. Yo entiendo, pero sí hay razón para preocupar. Yo siempre voy a decir la verdad. No estoy aquí para asustar, pero ese sí está dando otro poder al presidente para deportar gente más rápido. La ley siempre ha dicho 2 años, pero en práctica cada presidente ha usado 14 días, menos de 100 millas la frontera. Esas personas podían ser deportadas rápido sin ver un juez, pero ya Trump dijo, no, yo quiero cambiarlo, yo quiero usarlo para todos que tienen menos de 2 años aquí. Por eso es tan importante ya que estamos preparados para probar que tiene más de 2 años aquí. Yo no estoy diciendo que tiene que tener con usted documentos todo el tiempo diciendo eso, pero yo sí pienso que sí es buena idea que alguien en su familia sabe dónde están documentos, algunos probando que tiene más de 2 años aquí, para que cuando usted está con migración, ojalá que no, pero si usted está con más migración, tiene la posibilidad muy fácil de decir, oh no, oficial, yo sí puedo probar que tengo más de 2 años aquí. ¿Okay? Esa es la decisión del Corte de Apelación de Washington, D.C. Luego, el Corte Suprema hizo una decisión hoy. Era 7-2, nada más Sotomayor y Kagan a nuestro favor. Y fue basado en un caso de deportación rápido. Esa persona entró al país, fue negado después que dijo que tenía miedo de oficial de asilo. Fue negado por el supervisor. Lo pasaron al juez de inmigración, también negaron ahí. Normalmente, antes de 2019, eso era el fin de todo. Ya no podía hacer nada más, iba a ser deportado a su país de origen. En 2019, una corte de apelación en San Francisco puso un argumento excelente que se llama habeas corpus y due process, que violó los derechos de esa persona a este proceso y tiene derecho de un juez de distrito federal, que es un juez de veras, tiene poder de revisar el caso. El Corte Suprema tomó este caso y hoy pusieron decisión que ya no es cierto. Una persona que apenas entró al país, que tiene muy poco tiempo aquí, él tenía como minutos en el país, no puede pedir lo que se llama el habeas para que pueda pelear su caso de asilo. La palabra habeas siempre hemos usado y revisen toda la historia de este tipo de ley que podamos usar cuando una persona está detenido y pedimos la libertad porque está injustamente detenido. Todavía podemos usar eso en personas detenidas de migración, nada más no podemos usarlo para el argumento que el proceso de miedo razonable, miedo creíble no es suficiente, nada más si una persona está detenido. Muchas personas estaban diciendo hoy, Ruth Bader Ginsburg nos dejó, estaba en contra de nosotros. Leyendo la decisión de ella, ella sí votó en contra de este señor. Pero el bueno ahí es que ella está dejando espacio para que posiblemente alguien más viene a hacer un mejor argumento que tiene a lo mejor 1 año, 9 meses, 1 año, 10 meses. Esos tipos de personas que tienen más conexiones que todavía puede poner el mismo argumento. Aunque ella no está con nosotros, de todos modos la decisión de ella no era tan mal. Ella está muy claro basado en esta persona. Yo no estoy de acuerdo, pero quiero dejar la posibilidad en el futuro que alguien más que está teniendo migración sí puede hacer un argumento muy similar. Okay? So we got questions here. How is the outcome of this case different from new proposed asylum rules from DHS? Eso tenemos que hacer otro video. Creo que el abogado Juliana está siendo voluntaria a explicar las nuevas reglas de asilo del Departamento de Seguridad Nacional. Eso también, comunidad, es otro ataque, otro golpe a nosotros. Lo están pidiendo ahorita, lo están intentando a cambiar cómo una persona puede probar miedo creíble o miedo razonable, hacerlo más difícil. lo están intentando deportar a la gente más rápido, lo están intentando a hacerlo más difícil conseguir permiso de trabajo. Ya quieren que espera todo un año para que pueda pedir la gente que está pidiendo asilo un permiso de trabajo. Es diferente. Lo están intentando hacer cosas más peores el presidente bajo las nuevas reglas de asilo. Y esta decisión hoy nos puede afectar negativamente también, diciendo por el lado de habeas, no podemos poner demanda, pero no toca nada la ley de APA, Administrative Procedures Act. Entonces todavía puede seguir demandas en contra de eso, violación de APA y violación del due process, como sigue el caso en Washington, D.C. Okay? So eso no es completamente negativa. Does this mean that people have to carry on proof they've been here for more than 2 years? Yo no pienso que es necesario que cada persona alrededor del país siempre tiene que cargar con ellos pruebas que tienen más de 2 años en el país. Pero yo sí recomiendo que en su casa tiene algún paquete que todos en la familia saben dónde está, para que rápido, si está detenido, le pueda mandar al abogado la prueba. El abogado le puede mandar a ICE diciendo, no, mira, aquí está la prueba que mi gente tiene más de 2 años aquí en el país. No quiero poner tanto miedo a la comunidad que eso va a afectar y ICE va a empezar a parar cada persona o checkpoints adentro del país. Yo no pienso que va a pasar así, pero yo sí pienso que en algunos toma meses ICE para entender las decisiones y cambiar cómo ellos actúan, pero yo sí pienso que es necesario, ya estamos preparados en caso si una persona está detenida y están listos a explicar y entender por qué lo están preguntando los 2 años. So aquí es donde necesitamos muchísimo más educación en la comunidad y estoy pidiendo que ustedes me ayuden a compartir. Si ICE está pidiendo pruebas que una persona tiene más de 2 años en el país, esto es la razón. Lo quieren intentar negar su derecho a hablar con el juez y es muy importante a todos que estamos listos a probar que tiene más de 2 años para que sí podamos hacer una pelea en frente del juez de inmigración y no seamos deportados rápidos. Right? Keep dropping down your questions. Cualquier persona que tiene preguntas, pongas abajo, por favor. Pregunta, abogado, mi nombre es Margarito. ¿Cómo estás, Margarito? Can I reapply for DACA? So anybody that was in the program, 1,000% anybody that was ever in the DACA program, it is still open to reapply for that if you ever had the work permit part of the program. If you applied, I'm hearing people say, I applied, an attorney told me because I applied, therefore I'm in the program and I can renew now. I don't know what they're talking about. It sounds like they just wanted that person's money. So if you've been in the program before, I say you can reapply. For those that applied but were denied for some reason, I still am very cautious and I'm not sending anything off until we have more official word from USCIS, until we have an order from a federal judge giving us authority and ordering USCIS to take those applications. And I'm hoping we see that sometime in the near future. Understanding again that a lot of people are going with a different avenue, and I hope they're successful and hope they pave the way for the rest of us. But in the meantime, my rule here at the office is I don't want to put anybody in a worse situation than when they came in to meet me. Now, if somebody says, Abogado, I understand the risk, I understand what's happening, but let's do it anyways. That's my kind of person. That's who I want to roll with, and let's get in the ring and let's start throwing down, right? But for the most part, we're talking about 16, 17-year-old kids in high school. I don't see a need to rush off and send ICE or USCIS where they've lived at, what their parents' names are, with the possibility of this orange guy winning another 4 years. And the guy head of USCIS saying the crazy things he's doing right now. So I'm just taking a little bit slower, a little bit more cautious, and hope we do get a formal order from a court or USCIS smartens up and they decide to do the right thing. All right? ¿Alguien más con preguntas, con comentarios? Por favor, pongan abajo. Please, please, please. Now is your chance. Quick reminder and update. You can renew your DACA, right? Puede renovar su DACA si estaba en el programa antes. Todavía no. El decisión hoy de Corte Suprema sí es mal, pero no es nada increíble mal que yo estoy llorando. ¿verdad? Otra vez lo estamos regresando como fue en 2018. Yo, la abogada Juliana, hemos ganado cuando el oficial de asilo dijo no. Hemos ido enfrente del juez y decir, juez, aquí está la oficina por sí. Sí, mi cliente califica por miedo creíble y debe tener chance de quedar aquí y pelear su caso. Hemos ganado esos casos. Vamos a seguir ganando esos casos enfrente de los jueces. La decisión de hoy no me importa que salió en contra de nosotros. Era algo muy bueno que ganamos hace un año y medio en el primer circuito. Ya nos tenemos, de todos modos, regresamos como estábamos en 2018 y antes. Nunca era la manera que tuvimos por un poco de tiempo. So, yo estoy bien, seguimos peleando, seguimos defendiendo, seguimos dando una pelea más duro que podemos a ICE si ellos quieren deportar a una persona o si ellos no quieren que una persona viene aquí cuando está huyendo violencia de su país de origen. All right? Hello, Ray. Do DACA applicants qualify for unemployment insurance benefits? If so, is it considered a public charge? Great question from Mitzi. Thank you so much. So one thing to remember here, an unemployment, when we're talking about unemployment is considered an earned benefit. So you can only get unemployment if you worked, contributed to the system, so you earned it, right? Earned benefits are treated much differently than other types of benefits where you're just getting it when you didn't do anything for it. So an earned benefit is okay. And I also want to show everybody the USCIS public charge COVID language, just so everybody has an understanding straight what USCIS is saying. Let me see if they still have it up. Okay, let's go over here. So here's the public charge language. What they're very specific about is that they are saying if you're going to get a test, get the test, get it done. And over here it talks about the benefits. If you do receive any benefits, for example, if the alien is prevented from working or attending school, must rely on public benefits for the duration of COVID-19 outbreak or recovery phase, the person, let's get rid of that language, can provide an explanation and relevant supporting, not high enough, right? And relevant supporting documentation to the extent relevant and credible. USCIS will take all such evidence into consideration in the totality of circumstances. So it's even saying there when we're talking about some other stuff, we don't want to go there, but I just wanted to show the language, how USCIS is aware of COVID, and they are, looks like they're ready to give some leeway if someone does something in that area. But for the most part, to be honest with you, I would consider it an earned benefit anyways and good to go. All right, specifically for COVID relief. Yep. So there seems like they're going to be much better on the COVID relief stuff than on anything else. All right. Anybody else has any questions, comments, concerns? Feel free to drop them down. Again, not happy with decisions today, but they're not the end of the world. Not as bad as if DACA came out negatively. Of course, my pleasure, Mitzi. So, you know, we take our lumps and we keep getting up again the next day and we get back in the ring for the next round. The immigration world right now is one of those constant attacks where, yeah, I mean, you feel like you're in the ring with your best hand tied behind your back and it's the referee and the other fighter ganging up on you at the same time. That's practicing immigration law right now. We saw yesterday, and I had the pleasure of being on China Global Television Network yesterday, talking about the cancellation of the H-1B and other visa programs and the DACA decision. And to me, it just amazes me how the Republican administration is so intent on getting rid of these visas for people who come over and want to work and be part of the best corporations in the world, the Apples, the Googles, the Microsoft. These visas have allowed these companies to become the household names internationally that they are today. If it weren't for these people coming over with these kinds of visas and contributing to those companies, contributing to our society, contributing diversity to our community, we would not be in the position, especially these companies would not be in the position that they are today. And now we have the Trump administration basically saying, no, we no longer want the best of the best. We no longer want the brightest of the brightest from all over the world. They can stay there in their own countries and they can work for those companies. We instead want to not let in the best of the best. So think of it in the baseball standards. What's next? Are we going to not let anybody from Latin America in, and you have to be U.S. born to make a Major League Baseball team? Because that's the equivalent of what Trump is doing with canceling these visas. Exactly the same. We want the best players, so we have the best team, the best opportunity to win. We have been that beacon for decades now for people across the world to leave their country, to say, I'm going to take my talent, I'm going to take my knowledge, I'm going to take everything I know and contribute to these companies in the United States of America. And now Trump says, you know what? We don't want that. We'd rather have American-born people fill those jobs. What we want is the best people, the all-stars, that we say here at our office all the time. You're here, you're an all-star. You're the best person for the position. That's what you're doing. That's how we want to continue to build not only this country, but this world, with the best of the best being free to go wherever they want, work for whoever they want, and employers to employ who they want. And this is another slap in the face from the Trump administration to immigrants of color, because that's essentially who he wants to keep out. All right, that's my rant for the night. Hope everybody has a wonderful, wonderful evening. And another video comes out. Any update on DACA, we'll sure let you know very quickly. Thanks so much, everybody. Have a great night.